Do you have anything to say about those restrictions, taking it down in value to such an extent?
Those are, I'd say two things in response to that. First, the Shubin affidavit directly addresses that. That was improperly kind of disregarded.
He says there are no restrictions on it. He says there aren't, Shubin says there are no restrictions.
He says you have to interpret, he says the trial court looks at one document in isolation, the deed of conservation. Mr. Shubin says you got to look at all 5 documents, including the historical practice there, to understand what the actual policy is. And for example, they say he couldn't value it as a private residence, but he's been using it as a private residence since 1995, continuously to this day. But the more fundamental point is that valuation, where he relied on a tax assessment, illustrates the hazards to the marketplace as a whole here from having the Supreme Court cite things like Chico Marx in footnote 9 of the summary judgment position, the I know it when I see it standard from obscenity law from Justice Potter Stewart to decide what's a misrepresentation in these statements. When you have expert testimony unrebutted that says these are gap consistent, if we have a system where you can issue perfectly accounting clear basically statements that comply with gap, and you're held, well, we have another standard, I know it when I see it, that's good, that's bad. People can't do business in real estate. So,
Thank you,
Your Honor.
Oh, I'm sorry, there's another question.
Oh.
Sir, are you asking us to draw any bright line rules as to the contour of the AG's authority under 6312? Or are you asking us to scrutinize the evidence that was adduced either at summary judgment with respect to claim number 1 and then at trial with respect to 2 through 7?
The latter, Your Honor. So our argument is on the unique facts of this case, you cannot come to the conclusion that the plain language of the statute was violated. And we argue, obviously, that they raises constitutional questions as well under Grasso and under the excessive fines clause and so forth. We make all those interpretive arguments. But the fundamental point is, if you look at these unique facts on this case, the statute just doesn't cover it. And if it does, it has no limitation.
It's your position that under the facts of this case, 6312 didn't support the taking the action that was taken.
That's exactly right, Your Honor. Thank you, Your Honor.
Good afternoon, Your Honors. Brian Isaac, as you know, I represent the non-party appellant attorneys. My argument is not as sexy as the other arguments, but I think it's a hugely important argument to me as an appellate litigator. I think that the New York State judicial system is the best in the world. I don't think it's better arithmetically. I think it's better geometrically. And I think most of the credit goes to you, but some of it goes to us also. You can't do your job in an exemplary fashion unless we do our job competently. And every single lawyer who practices in New York knows it's not what you get at the trial level, it's what you keep in the appellate division. It is an absolutely horrible idea, in my judgment, to sanction attorneys for making motions for summary judgment in cases where they have to do it to preserve the issue, not only here, Your Honors.
You don't want to take a chance on the appellate court saying, oh, they didn't preserve the issue.
Judge, it's not only here. This is a Trump case. Like him, don't like him, it doesn't matter. This case is a case that definitionally could go to the Court of Appeals. Look at 522B41, look at Cialina against Erie Preserve, look at the number of amicus briefs that you had. I couldn't even read them. You have to preserve these issues. And there's one fact that I want to bring to your attention. I know you know it, but we probably should have brought it out in the brief more. You have interest of justice jurisdiction. You can, if you want, decide unpreserved issues. You almost never do it if you don't believe me. Just run my name. Just put Brian J. Isaac, in quotes, within 8, put preserved, unpreserved, not preserved. See how good I've done. I'm not 0 for 5. I'm not 0 for 10. I'm 0 for 3 decades on that. But this court can do it. The Court of Appeals can't. They do not have any interest of justice jurisdiction. They are not allowed to decide mixed questions of law and fact. They can't decide damage issues. They can't decide that a case is against the credible weight of the evidence. How can a competent attorney, and these people are competent attorneys, risk a $440 million malpractice claim by not raising an argument that's a tenable argument? And I'm not going to go over my time because I don't, but I wanted to say something to you. The Attorney General and the trial judge excoriated the lawyers for making a motion for summary judgment on disgorgement at the summary judgment level. One of the cases they rely on is People against Ernst & Young, which you know. Can I read to you what you said? This isn't Brian Isaac. It's not Michael Ross who wrote the brief for me. This is the Appellate Division First Department. I'm reading it verbatim. Quote, therefore, while the Attorney General does not allege direct injury to the public or consumers as a result of defendants' alleged collusion with Lehman Brothers in committing fraud, the equitable remedy of disgorgement is available in this action. Here's the key point. And it was premature to categorically preclude it at the pleading stage. That's verbatim. That is exactly what these lawyers did. And to be sanctioned for it is just wrong and threatens the integrity of what I think is the greatest juridical system we've seen. You shouldn't allow it.
Thank you. Counsel. So you have 10 minutes on this first. You have 10 minutes on this.
Well, I don't know if it's easier, Your Honor. Since we're the appellees, I'm happy to just take the full 15 minutes as the appellee, and that I
Okay.
think that maybe simplifies things. May it please the court, Judith Vale for the New York Attorney General's office. All of the defendants repeatedly
Ms.
violated.
Vale, can you identify any previous case in which the Attorney General sued under Executive Law 6312 to upset a private business transaction that was between equally sophisticated partners, where the supposed victim had the ability and legal obligation to discover the allegedly misrepresented matters by conducting its own due diligence, where the supposed wrongdoer advised the supposed victim through written disclaimers to conduct its own due diligence and to draw its own conclusions, where the alleged misrepresentation almost entirely concerned inherently subjective valuations of properties and businesses,
Yes,
and where the victim never complained about any fraud of the transactional losses from it. Because I've gone through the cases which you've cited, and all of them always involved the consumer protection aspect. It involved protection of the market.
several
And
responses.
I want to add to his question, and little to no impact on the public marketplace.
Well, maybe I'll take that first, Your Honor, and work backwards. There was absolutely a public impact and a public interest here. There are at least 4 different public harms from the kind of misconduct here. First of all, when deceptively hidden risks are injected into the market, that does hurt the counterparties, and there was harm to the counterparties here, but it also harms other market participants and the market as a whole because they are not understanding the risks, they are not pricing them in properly, and they are not prepared for what might happen if the true risks come to pass. Also, as the legislature made clear in passing 6312, it was concerned with harms to the honest business people who don't do the misconduct and therefore don't get the kind of benefit that they got here.
I suppose you're referring to the fact that Trump received a lower interest rate than he might otherwise have received. But haven't you yourself conceded that the assets were sufficient to get the lower interest rate of the private wealth management direction?
Absolutely not, Your Honor. That is not conceded one bit, and the evidence is to the contrary. If you look at what the Deutsche Bank witnesses testified to, Haig said that the financial strength of the guarantor affects the pricing in terms of the loan. That's in the record at 28167 to 68, and it affects whether the private wealth management group would be allowed to do this deal at all. That's at 28150 of the record. And you have to remember something. As the net worth as the statements were coming in, the Deutsche Bank was doing a stress test. So if without the fraud, the net worth and liquidity would have started much lower. And then you do the stress test and it takes it down much lower. It does not look like such a strong financial guarantee anymore. It does not look like an ironclad guarantee anymore. And it was absolutely a fair inference that Deutsche Bank would not have given these loans without the financial strength being inflated. That was also evident from Haig and McCarty testifying about the incredible
Doesn't Mr.
collateral.
Doesn't Mr. Hay testify that there were 14 factors and this was the least important factor?
Well, certainly there are multiple factors that go into the risk assessment, but both for materiality and for disgorgement, the issue is not whether there's only one factor. There's often a lot of factors
that
that are being
point.
considered. For materiality, it's whether it's important to the overall total mix of information. And this was absolutely critical to the overall mix of information, not only because they were looking specifically at what the net worth was in order to decide the terms of the loan, in order to figure out whether they would take on this risk, but also the financial statements were coming in each year, and they were important, critical to the loans each year, because Deutsche Bank was reassessing the risk every single year, and it was using.
Sorry, but what's being described sounds an awful lot like a potential commercial dispute between private actors.
Well, to go back to the first question about whether there's other examples of this, there are other examples of this. In the first American case, the Attorney General brought a 6312 case where the transaction at issue was between a very big bank, Wells Fargo, and a professional appraisal firm.
But wasn't the concern there that the public would ultimately be negatively impacted, affected by what those corporate actors were doing?
And that concern is here as well, because when you have hidden risks getting injected into the market, that hurts the market and honest participants in the market. And the legislature also decided, contrary to what defendants think, that making sure that business in New York stays honest is the way to attract and keep business
So to that
in New
point,
York.
the Executive Law 6312, I just want to read a section of it. Well, not exactly, but was enacted to promote and protect honesty and integrity. It's the same question I asked the other side. In commercial marketplaces in New York by stopping fraudulent and illegal businesses. To accomplish this purpose, the statute authorizes the Attorney General to bring civil enforcement proceedings on behalf of the people whenever any person shall engage in repeated fraudulent or illegal acts or otherwise demonstrate persistent fraud or illegality in the carrying on, conducting, or transacting of business. I don't read harm or threat of harm in that, but the other side is saying that that is to be read into the statute. Are there any cases where the language